right. Welcome everybody. We're going to get started. I think we may still have some people trickling in later. If anyone doesn't know me, I'm Brett Landis. I'm current president of the BCPA board. And I am really excited for today's presentation. I know it's a tough topic to talk about succession planning, but I think it's a really important one, and I'm really glad to see that there are so many people here today. I am also excited that one of our board members, Jodi Martin, is presenting today. Jodi relocated to Colorado in 2012 and founded the Martin Law Office, LLC, to pursue a practice focused on using her legal experience to help her clients strengthen and protect themselves and their families. In light of her nearly 25 years of legal experience, Jodi is skilled in working with clients to resolve disputes outside of the courtroom, but is also fully prepared to litigate matters when needed. Jodi's practice focuses on estate planning, probate and estate administration, probate and trust litigation, family law, and LGBTQ legal matters. And I am going to go ahead and let Jodi take it away from here. She does have materials that are being sent to you by email. So check your emails afterwards to get copies of everything, and take it away.
Thank you. Hi, thank you all for coming. This is an exciting topic, I'm sure, for everybody. I live in the world of estate planning, so as my family will tell you, I talk about death and lots of fun things all the time. It drives them crazy, so we're not just going to talk about dying today. There's much more to what we're going to talk about, thankfully. Otherwise, nobody would really want to deal with this stuff. So a little bit about kind of what I've set up for today. So I do have some slides. We'll go through those. It helps keep me on track because I can tend to kind of go off on tangents sometimes, and so it's really good for me. It's also good to give you guys guide points, but Kyle does have the slides in PDF form, so you'll get the slides. Also, we will talk about a document that the Office of Attorney Regulation Council has put out. We're going to talk about that a little bit as we go through things. And that is provided in the materials, as well as a link, because the parts of that, it's about a 62-page document. Parts of that are also available in Word because they're forms that you can use to do some of the things we're talking about. So you get those as part of your materials as well. And I'm always open if you have questions after today. As we go forward, feel free if you have a question or comment to chime in. I'm not going to be super structured about saving those till the end because sometimes we forget what they are if we do that. So feel free. Otherwise, let's kind of get started. So this is who I am. I do have a law firm here in Boulder. I am a solo practitioner, so that's part of why this is something that's relevant to me. Also, it's relevant to me because I am, as my spouse will tell me and remind me frequently, I am past the midway point, according to most statistics. So we look at that, but also I do estate planning, so it's something that's relevant. If I tell my clients they need to do things, I kind of figure I should be looking at them as well. So I did put some stats in here just to kind of focus us. This comes from the OARC, so Office of Attorney Regulation Council. I'm going to use the acronym several times for, but this is from their 2020 annual report. Of course, I think numbers are only as good as the responses they get, but I do find some of these numbers interesting, and I think they're relevant to our topic. So this is statewide, active attorneys by age. You can see, I didn't grab the under 50, but there are obviously people under 50 in these numbers. But for our purposes, especially since we're talking about succession planning, I kind of grabbed the 50 and above, but we've got some pretty good chunks in there. Even have a few folks that are 90 plus that are still kicking it in the legal world. So good for them, hopefully. So that's by age, but then we get into, I think I skipped a slide on us.
Is this Colorado or?
This is Colorado specific, yep. These are by type of firm. So 5,620 attorneys out there are solo, and then you see about 5,000 are small firm and so forth. I didn't include, again, the numbers for government attorneys. I'm pretty sure none of you are government attorneys. Because you're not doing the same sort of stuff that we'll talk about. But so yeah, there's some other nonprofit, public entities, that sort of thing are not in there. Solos by the number. I do think that a big part of what we're talking about here are solos, but we do talk about other areas as well. But 1,500 or 37% of those in that 60 to 69 bracket are solo practitioners. 49, so roughly 50% of those 70 to 79 are solo practitioners. So those are some pretty big numbers when you think about, what's going to happen to their files, their firm, and so forth, so on if something happens. There's also an interesting number on the OARC report that 39% of solos do not have malpractice insurance. I'm not here to preach malpractice insurance, but I do know that if you haven't done your succession planning, you kind of might want to have malpractice insurance in the back pocket to help your family. So as we get started, now that I've thrown some solo numbers out there, I would like a little idea of who I'm talking to. So do we have any solo practitioners in the room? I know a few people, so I know we do have some. Okay. What about small or mid-sized firms? Okay. How many?
Just 2 attorneys.
Okay, that's right. So really, some of the solo stuff that we'll talk about is also somewhat relevant to a true attorney firm. But we're also going to talk about small firms, some things that can be done there, and even some folks that are maybe shareholders in some bigger firms. So we're going to hit a few buckets, not necessarily going to hit your bucket. But yeah, so moving on. The ethics of it all, because we can't really talk about some of this without coming into why in the heck do we care, right? So one of the reasons we care is because they tell us as lawyers we have to care. Rule 1.1, duty of competent representation, says that we should be safeguarding our client's interest in the event of our death, disability. Love it when one of your devices loses connection, but you have a backup. Death, disability, impairment, or incapacity, and that's also echoed in an ABA formal opinion. Then 1.3, duty of diligence. The comments of that specifically address our responsibility as a solo practitioner to prepare a plan in conformity with applicable rules that designates another competent lawyer to review our client files, notify clients of our death or disability, and determine whether there's a need for immediate protective action. So the comments specifically address what we're talking about for solos. 1.15, safeguarding the property of our clients and third parties, also touches on this. And then your malpractice carrier, if you're one of the 63% of solo practitioners who have malpractice, you may have one of the carriers that requires something. My carrier does. They require that I identify what's going to be called a coverage attorney, and we'll talk about that in some of the stuff we get into. They don't necessarily say, hey, Jodi, have you done your succession planning? But they do want me to say that I have a coverage attorney in case I suddenly get sick with COVID and can't appear at those hearings that I might have set. So I have to designate who that is with my malpractice carrier every year. Not every company requires that, but a lot of them do, and I think it's becoming more of a thing with solo practitioners and malpractice. All right. So when would this apply to you? So we're not just talking about death, we're also talking about disability, incapacity, impairment. That can be temporary or permanent. So COVID, prime example, right? If before vaccines and other things had become available, and even now while we have high hospitalization rates, if a solo practitioner specifically came down with COVID and was out of the office and unable to work even remotely for an extended period of time, this is going to apply to them. As a solo, it was something I was monitoring all the time, just the idea of what do I have set on dockets, do I have coverage, those sorts of things. Death, vacation. I recently took another vacation. Thankfully, we're sort of getting back into that mode of the world again, and it's one of the things you think about, right? If something blows up, I do some litigation. So if something blows up in litigation, especially, who's going to answer that call? Disbarment or suspension, it happens. And then also retirement, because I think all of us at some point hope there's a day that we kind of hit that level as well. Maybe not wait till 90, but maybe, I don't know, each their own. All right. So we're going to break this down into temporary and permanent because there are different issues that are going to arise. This is not everything. This is just some kind of high points, if you will, of some of the things that can come up. So a temporary absence from the firm. This is going to apply to solo. It's going to apply to small firms. Some of them apply to larger firms, but some of them are pretty basic, right? We think about them pretty routinely. Court dates that are missed. Client deadlines or commitments to clients. If I'm temporarily out, these are things that might pop up. Incoming matters, my pipeline. you're in a bigger firm, if you're in a small firm, if you're a solo practitioner, your bread and butter is incoming stuff, right? If I finish one estate plan, I hope I have another one in the burner, or I'm going to have a tough week. So it's that pipeline, and is it going to keep going? Keeping the current clients, are they going to be like, hey, Jodi's in the wind again, she must be in, Mexico, forget that. Keeping the business alive, that's more solo practitioner kind of worries, but it can hit any firm, especially small. Income, right? So I have a temporary absence. Does that mean I don't get any income, right? So what if I have a month that I can't work because I've been in a bad car accident and I'm, hospitalized and unable to work in any form or fashion for a month? It's temporary, but where's my income? And have I done anything to prepare for that? Trust account. Our trust accounts, you have to remember in thinking about them in this context, they are only accessible to Colorado licensed attorneys. So I can't depend on, a non-attorney. So somebody might say, well, I have a power of attorney and my spouse has power of attorney to do all sorts of things for me. Are they a Colorado attorney? If they're not touching your trust account. If they are a Colorado attorney, they may or may not even need, they may also need some court authorization to touch it depending on what they're doing. But there are ways you can get somebody set up, and we're going to talk about that. So, but your trust account is a big one, because if I have a brand new, so I do some, probate litigation. If I have a brand new probate litigation case, and then I have that bad accident, they've given me a retainer, it's sitting in my account, and my staff calls and says, hey, Jodi's not going to be back for 2 months. We need to get you somebody else. Well, I need my retainer back. Who can give them that retainer back, right? And that's a temporary issue or a temporary absence that kicks that up. Employees, do you have staff, right? Do you have other attorneys in your office or staff that are reliant on you working to be able to pay their paycheck? Office lease and expenses. Some people, now that we've kind of gone through COVID, we've got more folks working remote. Leasing may not be as big of a worry, but you probably have some monthly expenses, some overhead, and have you arranged for those things to be taken care of. So these are some of the issues that come up with a temporary absence. So what are some solutions, right? Let's talk about some of the initial basic solutions, some of which we often hate to think about, keeping our billing up to date. As somebody who does hourly billing as well as some flat fee work, billing is just one of those things most lawyers, we love to do it because we get paid, we hate to do it because it's paperwork, right? But keeping it up to date, because again, something happened to me and I'm a month behind in billing and I haven't entered things, am I actually going to get paid for all that time? Because nobody can reinvent what I have, in my head or my notes. File notes and info. I've got a coverage attorney maybe lined up, but can they open that file? Can they grab that file and walk into court and actually know what they're talking about? If my file's not up to date in some form or fashion, they may not be able to do that. If they need to take over an estate plan for someone who is of poor health and so it needs to get done, do they have my intake notes on what that person needs or wants? Calendar management, right? That's a big one, because again, if I don't have my court dates on there, forget it. So these are all kind of things that we sort of know already, right? I'm not telling you anything new. Reliable staff with knowledge of your systems and emergency contacts. If you have staff, a lot of folks don't necessarily have staff. And so is there some way that I could walk in as your coverage attorney and look at stuff and be able to help you? Or am I just shooting in the dark, right? That's kind of the question. Cross-training, if you have multi-attorney firms, it is, my career trajectory has been varied. I started as a criminal prosecutor in another state in the largest prosecutor's office in the state. And, there was some cross-training, but you were sort of in your little neck of the woods. And I did special victims crimes. You couldn't get a drug attorney to come try one of my cases. I wouldn't want them to do that. I then went into a mid-sized civil rights law firm, and same thing. There wasn't a lot of cross-training. Well, if I was out, there wasn't somebody that could pick up that file. And so part of your succession planning should be, if you have other attorneys that you're working with in some, either as partners in the firm, as associates, or as a coverage attorney, have you done some cross-training so they know what they're doing, right? I'm not necessarily going to have my coverage attorney on a family law case be an estate planning attorney. It's not fair to them. It's not fair to the client, right? That's the idea. So none of these, you'll notice, necessarily allow for financial management of that trust account. And all of these really apply no matter kind of what size of firm you're dealing with. Then we get into some other things. Disability insurance. That's a big one. It's actually somewhat uncommon amongst attorneys, but it is something that would help you with that income stream. There are a lot of options on that. I know one attendee, I will put a plug in for him because he was hoping to be here. Kurt Hofgaard is always happy to answer questions about disability insurance. And he's a fellow attorney here in town. Have a designated coverage attorney. It could be a coworker, or for a solo, it could be somebody that you have a specific agreement with. I have a pretty diverse set of practice areas. I have a couple of coverage attorneys, right? I do some family law work, so I have a family law attorney. If I'm going on vacation, I say, hey, will you take all of those calls? And my paralegal knows that's who the person is. If somebody calls in, or if I'm dealing with an estate or a probate litigation, it's a different attorney. And that's in consideration of them as much as it is for my clients. But do you have who that person is that you're designating? That doesn't have to be in writing, right? There's nothing about that has to be written. That's just an agreement. If somebody calls in a crisis in one of my family law cases, my paralegal knows to call that coverage attorney. If I have a hearing, that's who's already arranged to go there, and I've given them a background of what's going on. But that's your coverage attorney. So that's sort of a planned temporary absence, right? But it can also be somebody who's there. If I was to get sick, my coverage attorneys know that they're going to get a call that says, hey, Jodi's, sick and not going to be able to work, or this is going on, and they know they could be contacted to assist with that. And that's the attorney that my malpractice knows about at a base level, okay? Power of attorney limited. That's to access your bank accounts, right? We do powers of attorney when we do estate planning for all sorts of clients. This is limited. This is focused on my firm accounts. So I have a limited power of attorney, perhaps, that says that Sally Smith can handle my operating account and my trust account. That means, in that example I gave earlier where the client needs their retainer back, Sally Smith could use the limited power of attorney to take care of that client without triggering a complaint to, bar complaint or OARC getting a call. They can step in and help with that. You can also use an authorized signer on all your accounts. That's another way to set that up. And one thing, I think it pops up later in the slides as well, with the limited power of attorney and the authorized signer is going to happen with your bank, right? So the bank already knows about it. If you do a limited power of attorney, you do want to talk to your bank so they have an idea that this exists. So you make sure that you've checked all the boxes with them, because every bank is a little different. And we want to make sure they have what they need so they're going to honor it. The other thing you can do, and it comes up later, is a letter, forgotten the name of it, but it's basically a letter of instruction. So if I've said Sally Smith has my limited power of attorney, but I don't necessarily want Sally holding on to that power of attorney because it just feels like I'm giving her a little too much power over my firm, what you can do is a letter of instruction to a loved one, it could be a spouse, it could be a friend, a sibling, whatever the case may be, but give a loved one a letter of instruction that says, okay, here is my original limited power of attorney, this is where I put it, this is the instruction to you of who to give it to and how to give it to them if something happens. So that you kind of put a little extra barrier in there, because sometimes folks it is a little nerve-wracking, right, to give somebody a power of attorney over our trust account, especially in our operating. So those are some options. Assisting attorney for a solo, and you'll see it's kind of a little bit bolded. I don't know if it stands out. And the reason for that is we're going to talk about that a little bit more in depth as we move through this. But that's the other thing, is an assisting attorney. That is a much bigger task. An assisting attorney is someone who's actually going to be able to step in and sort of take over and run some things for me. And so we're going to come back to that here in a little bit. All right? Whoops, I did it again. One too many. Okay, permanent absence. These are some issues that pop up. Some of them are the same, right? Deadlines, court dates, but also avoiding litigation and bar complaints. It falls into temporary as well. But if it's a permanent absence, there's a huge risk now happening if we haven't done anything. And so that's why it's added there. Again, trust account employees, obviously some of those are more small firm, solo kind of issues than they are larger firms. So solutions when it's permanent, because you're going to have some different solutions. So you see we have some of the same, right? And so then we also have life insurance. Life insurance here is not the same as, I have a life insurance on myself. If something happens to me, the spouse gets, a check or a kid gets a check. That's not what we're talking about here. We're talking about life insurance that is maybe available to help keep the firm kind of functional and above or kind of afloat to wrap things up so that then there's some funds that can go, if there's something left over, that can go to my family. But it's a way to pay staff. It's a way to pay maybe an assisting attorney. It's a way to sort of fund the firm because I'm not there doing the billing, right? That's the idea here. Another way that life insurance comes up is a buy-sell agreement or a shareholder agreement. So those are going to come up more for small firms and multi-attorney firms, right? So as a solo practitioner, we don't have a buy-sell agreement with ourselves, right? But if we had two partners or more partners, we might have something that says that there's a way that the firm is going to buy out my interest in the firm, right? As a result of my death. So I have passed away and my interest in this partnership has a value and I want my heirs to receive that. A buy-sell agreement or a shareholder agreement is how we get there. And what we do is we can partner life insurance with those, right? Because if you think about like a two-person firm, if we said, okay, well, Jodi's interest in this two-person firm is, valued at $500,000, just to throw a number in there. That sounds great, but if I suddenly die, does the firm have $500,000 in cash to hand to my heirs? Probably not. And so how do they pay that out? Well, the buy-sell agreement sets out the terms of how they're going to pay that out and how they're going to value that and what it's going to look like and where my interest is paid to. And then the way they finance that, there's many levels to doing this. One of them would be to have a life insurance policy. That life insurance policy essentially funds the buyout of my interest. So my partner doesn't have to reach into the operating account and pull out $500,000 and hand it to my spouse. And my partner doesn't have to reach into their checkbook to do that. Instead, life insurance is notified of my death. They pay it out, and then it's paid out as part of the buy-sell agreement. And it could be that there's, some funds that I owe the firm or something else, and those come out of there. There's so many different ways that can be dealt with. But the idea is, if you have more than one attorney, you should be looking at some sort of a buy-sell agreement or a shareholder agreement if you have an interest in the firm. If you're an associate, firm's not going to give you a buy-sell agreement. They're not going to do that shareholder agreement either because you're an associate. But if you have an interest in the firm, those are the agreements that are going to help you get a value for that interest rather than your family being left with no value. And then you want to make sure that there's a way that they've got that funded because a buy-sell agreement can cause a business to literally just end up broke. If they've got this agreement, they have to pay funds out and they don't have them. Okay, business attorneys are your best source of information on those documents. That's where I would refer anybody to if you're working on those. In a small firm, you should, and really even in a solo, but it's more, if it's a solo, it's for your assisting attorney, but in a small firm, you really should have a mechanism so they have the ability to locate things like your passwords, your case information, client info, etc. And make sure that, there's a really good sentence, as well as make sure multiple are able to sign on accounts. I believe I meant multiple people. But essentially the idea is, and that would be like your emails and such, but the idea is it's the whole theory of digital assets, really, because I always use the example, and this is a really kind of ancient example, a long time ago, and it was on a sitcom, and I can't even tell you which one, but the spouse had died, and they had it was back before you could share your iTunes accounts, and they had all the good music. And the living spouse didn't have any music because the spouse had paid for all of it. You know, we used to pay for all the songs that way and couldn't share them. And so the spouse with the Apple password is the one that had died. And the living one was just really appalled that they couldn't get into the Apple iTunes, and they tried, and it was this whole thing. And so like the ghost of, you know, the spirit or whatever of the deceased one came back for something, and it was like, they did the whole, oh, miss you, that kind of thing. And then at the end, they were like, oh, I forgot to ask for the iTunes password. So,
Jodi,
you know.
I lived up until the ghost part.
Yep.
I literally had that happen in the case too.
Yeah,
Yeah,
it's
all
definitely.
music,
Not the ghost part?
books, yeah.
They just didn't
part
admit
was
it.
out, but like, and some family photos and things like that too that was going on the iCloud.
And I've currently got a case where they've hired Probate Council, and we've simply been hired to fight with Google and Apple to recover their deceased son's assets, because he was a photographer and all sorts of stuff and died young, and so we're trying to recover all that. And there's a process for that, but it doesn't quite work the same if it's, you know, firm assets, right? If it's, you know, the place like the Dropbox that I've set up for whatever reason that nobody else has access to. So it's about making sure, especially in a small firm, that they know where to get to things and how to get to things. As a solo practitioner, again, our assisting attorney is going to need the same information, and that's what we'll talk about when we get there. All right, so these two, I don't know why I didn't put a header on them, but they continue the discussion we just had about solutions: inventory counsel and assisting attorney. So we're going to dig into these a little more. Inventory counsel and assisting attorney are two solutions that are primarily for solos, though inventory counsel could potentially come into play in a small firm, but mostly this is going to happen for solos. I would note that if you think back to the temporary solutions, we talked about that limited power of attorney. Remember that powers of attorney die with us, right? So if I've given my limited power of attorney to another attorney to be able to access my trust account, that power died when I died. Now, if I've retired and that's the permanent nature, then that limited POA still applies. So you can kind of think back to that. But if it's a death that's occurred, that's gone. So now who can access my financial accounts is likely to be one of these two people if I'm a solo practitioner. Hopefully, if I'm in a small firm, we've both got, you know, rights as signers on the accounts and access. If it's a 2 or 3 person firm, if it's a big firm, you know, then you're going to have a few people that have access and ability to do that. All right, so let's get into some of these terms. Coverage attorney, we've talked a little bit about that, so we're not going to rehash some of that, but basically they're here to kind of cover some emergencies, usually a specific period of time or absence. It's kind of a planned thing, but it doesn't have to be planned. My coverage attorneys know, I mean, they could get contacted by my paralegal if I've had a bad accident and I have a hearing set. Doesn't mean they're going to have to argue the hearing, but they're going to be the one that reach out to the court. Limited in nature, they're not going to have access to every file I have, all of my clients' finances, my systems. They're really there just for covering kind of those emergent issues. All right, assisting attorney. We've talked about that term. So this is someone that I have designated authority to run my practice. Temporarily is the word here, but temporarily in the context of, as if it's a temporary absence, they're going to run it as long as needed to keep it afloat probably, or until we reach the point that it needs to be shut down, right? That's the idea. They're not just going to take over my firm and keep chugging along for, you know, decades. That's not the idea. If I wanted to do that, I can sell my practice, right? Or I can assign it to somebody. Those are different contexts. This is the idea of getting someone in that has authority to run things, and they're going to run the entire practice. And then if need be, close it, right? Hopefully, if it's a temporary incapacity, they're going to run it long enough that when I come back on board, I still have a firm to return to. That's the idea, right? If it's a death or something like that, they have authority to get it all wrapped up and taken care of. They generally are going to have access to your COLTAF account. That's a big part of why you do this. And so your agreement and documents with them are going to allow that. And this is formal documentation. This is paperwork. This is a lot of documents that make this happen. And we're going to talk about that a little bit. So next was Inventory Council.
Jodi, I've got a question.
Yeah, go for it.
So does the assisting council, in the event of a death, have authority to sell your practice and set a price for your practice?
So it depends how you draft the agreement,
Okay.
but theoretically, yeah. I mean, the idea would be to give them authority to close it and sell it or get some value out of it, if they can. Absolutely. All right, so Inventory Council. Inventory Council is different. This is appointed by the court on application of the Office of Attorney Regulation. This is, I didn't do my planning. Something happened, and now somebody's got to deal with it. That's what this is, right? And so just like I tell clients in estate planning, if you don't prepare a will, the state of Colorado has one for you. You might not like it, but it's there. That's the same concept, right? If I haven't done my planning, something happens, Inventory Council, which is an employee of the Office of Attorney Regulation Council, there are some volunteers that do this work as well. Their job is to come in, they get appointed by the court, they apply basically to the court to get appointed to be Inventory Counsel for my firm. It's applicable, so like I said, it could be a volunteer or it could be they have a staff attorney that does this. So for that to apply, the attorney has transferred to disability inactive status, disappeared, died, or been suspended or disbarred. If one of those things has happened and there's no other responsible party capable of conducting the attorney's affairs, at least that anybody knows about, then Inventory Council applies to the court to be appointed. Okay? That's how it's triggered. Yeah.
So obviously with Inventory Council, there's some sort of record with the Office of Attorney Regulation. Is that also true with an assisting attorney if you've done a succession plan?
Yeah.
So Office of Attorney Regulation may have no idea who's taking care of your firm's business.
Right. So
Okay.
the theory would be if I have an assisting attorney and OARC somehow gets notified that there's a problem with my firm, when they come in, they should in some way figure out that there's an assisting attorney. Yeah. And because an application is filed, there's going to be notices to some people, so it should pop up. It could fall through the cracks. So, all right. So then these are the rules that apply to Inventory Council. CRCP 244.1 through .4. That's what authorizes and defines the procedure for appointment. So if you're curious what that looks like, definitely that's where you can go. And then 251.32 provides that their job is to review the attorney's client files and take steps necessary to protect the interests of the attorney and the clients. They can disperse funds from your COLTAF. They can collect your computers, your phones, any digital device that might have client files or information is going to be collected. Their job is to go through and pull off and preserve any client data and information. I know from a friend of mine that when they do this, there's ways that you can ask them to preserve personal information to be returned to the family, but that computer is going to be wiped. And most of us in today's world probably don't carry 2 phones or 2 laptops. There's some commingling happening with our family photos and our work stuff. And just, you have to understand that this is their process. They come in, they seize, and then they go through it. Their process can take quite a while. So they say it can take months, but they also will acknowledge in information they put out that it can take years. It just depends what's going on. And so their job is to come in, and they're not going to worry about selling your practice for value. They're coming in, farming out client files to clients, using destruction policies that can be used to destroy things that, under the retention and destruction can be destroyed. And then they hold files that have to be held. And then they also disperse those funds. If they can find the people to disperse the funds to is the other key. We'll talk about that in a sec. This is, if you go to their website, and I put the link down here again, you'll get the materials and the slides. These are the files that are currently active under Inventory Council's control. So if you click on the link and go to the site, that's what an Inventory Council is working on right now. And actually at the bottom of the page, I didn't copy it, but there's another list of, I don't know, maybe 8 or 10. And those are being handled by volunteer attorneys because, of course, you know, Inventory Council's here, the Front Range, so you've got kind of the far corners of the state. When it comes up, they get some volunteer attorneys to help out. So, yeah.
So does that mean those people on the list are deceased or disabled or disbarred?
Yeah, one of the above. Could be disbarred or suspended, could be dead, could have disappeared in some fashion. Yeah.
Well, I hope my friend didn't disappear.
Yeah. I don't know any of the names, so that's a good point. I could have just given you some bad news, I guess.
It's all right.
But yeah, those are the ones that Inventory Council is working on. So according to their website, right, it's only as valid as their site. Yeah. So I rely on OARC. So
they have good systems there.
Yeah, right. So that's what they're working, and that's what would happen. So when they come in, that's how they do that, so that if somebody's looking for files, this is a way that you can figure out if that's who you should be contacting. That's the theory of them putting it on the website. Some numbers that they put out that I do think are interesting. So roughly 5,000, this is just 2020, roughly 5,000 was returned to clients from their trust accounts. 16,000 plus was sent to the Trust Account Foundation as unclaimed funds, right? I think the reality is, at the end of the day, most of us would much rather see our clients get their money back if something happened to us. And I think it does become harder when you have Inventory Council coming in and not knowing your procedures, not knowing your systems, and just trying to figure it out. And then this strange person, right, reaching out to your clients. I have plenty of clients that probably wouldn't take the call, not knowing who it was, right? So, you know, that's some interesting numbers. They filed 19 new petitions in 2020. So I don't know if that's high or low for them. I didn't research historical numbers, but all right. So making your own plan. This is, you know, alternative to Inventory Council, right? So get yourself or your firm in order, assisting attorney for solos, and get your documents in place for solos and some small firms. And also, I should have said also for even shareholders and partners in larger firms, right? Make sure that you've got something to protect your interest in that firm. So getting in order, step one, have a calendar system that is workable. So up to date, accessible if you're not there, staff in the know, something so that people know where you're supposed to be. I live and die by my calendar. I mean, it tells me where I'm supposed to be, and most people in my life know that, including my paralegal. And she has access to it. So if I suddenly had a bad accident, she can look at it, and hopefully would look at it and be like, oh, goodness, Jodi had court tomorrow. So that's the idea. And these steps are not in any particular order. It's just sort of the way it came to me as I was working on my materials. Trust account management. This is making sure your ledger is updated as it's supposed to be with clear details on funds by client and matter, so they know what goes to whom, so they can accurately return the funds, right? If they look at your account, whether it's, you know, in your QuickBooks or however you do your ledger versus if you have a case management system, can they tell how much, you know, Sally Smith is entitled to? That's the idea, and how much Sally Smith owes you out of that amount, right? Step 3, organize client files. Again, something we all kind of recognize. You know, can they tell, for those of us that do probate or any work, really, litigation sometimes, where you might have client property, whether it's in a safe or a secured area, can they tell whose property is what, right? This thing that might be really kind of a junky little watch might mean a lot to that family. Do they know who it belongs to if they come in to close down your firm? And that would apply even for Inventory Council, right? Step 4, billing and time entries, right? We've talked about that. And again, these are things that you can do the way to think about it is, can I break it down into steps and get some things taken care of before I really bite off the big piece? Or do I have to jump in and do all this stuff at once? And so I kind of broke it into some steps for things that you can look at initially to get yourself in order. Step 5, access, we've talked about. Then insurance, right? I think we have to think through how our family is going to be able to function if that income source is gone. But also, is my interest in a small firm going to be able to be paid or bought out so that there's some value to what I've worked for all those years? Step 7, again, documents, buy-sell agreement, shareholder agreement, other intra-firm agreements. Depending on what if you're in a large firm, there could be all sorts of titles they give the agreements. That's really, this slide isn't really a solo focused thing. And then the assisting attorney. All right, so if you want to designate who will be your inventory counsel, you need to do an assisting attorney agreement. And that's what we'll talk about here in the time we have left. This is, again, if you want to avoid OARC being appointed. Nothing against OARC, but most of us would like to have some control over who's doing what in our lives. And create a succession plan that includes, to get that, your assisting attorney. It can be simple, but it can also get very complex. You have some choice in how detailed your plan gets. You can consider, for instance, do you want your assisting attorney to be the one that determines if you're disabled, impaired, or incapacitated? So are they the determining factor? Do they need to have doctor's notes or letters determining that? Do they need to get a court determination? Do you want your spouse to determine? How do you want that figured out? You can literally include that in your assisting attorney paperwork. So does that person have the power to help with that decision or not? Do you want your assisting attorney to represent you, your clients, or no one? And this is an interesting thing to think through, because a lot of times people are like, well, I want them to represent me, but I also want them to be able to represent the clients. Well, there's a potential conflict there, because they start digging through your case file and they're like, okay, this is done wrong. Jodi made a mistake. She clearly wasn't with it that day. If they find those errors and they're representing you and the client, they now have an ethical problem, right? So you probably need to think through if you want that. Or do they represent no one? And what I mean by that is you could set it up in a way where your assisting attorney's job is more almost managerial rather than representative. So in other words, they come in sort of like inventory counsel, but a little bit more controlled and a little more set up. They come in and their job is they're going to go through my files and they're going to say, okay, this is the active family law pile. I'm going to reach out to these attorneys and see if any of them have space on their docket. Then I'm going to reach each client. Because remember, our clients get to choose who their lawyer is, right? So then they call the clients of those files and say, hey, Jodi's passed away. I have a list of attorneys that can take new files, or you can take your file elsewhere. Let's talk through what you want to do. They never say, I do divorce work, I'll take your file, right? That's not their role here. And that's the no one setup, right? That's where they're more in a management position rather than this turns into them taking over my firm. And there's a way too in that setup where they could wind things down to potentially sell the firm, right? Like Fern had asked about. Yeah.
So since you're killing yourself, we'll continue to kill
I do that a lot. Trust me.
Let's say you're dead. And you in your assisting attorney comes in, wants to be more managerial than representative, so assigns or finds other attorneys. Does that assignee attorney, what is the liability of that assignee attorney with respect to work you've done with respect to any given client?
It would be the same as if the client had fired me and said,
okay,
I'm going to go to Fern, I'm tired of Jodi.
Even if they use your...
Yeah, so you're going to give them most likely, your managing attorney is probably going to give them a few names just to avoid any potential, kind of issue. Now, the difference would be if they sold my practice, right? If they bundled up all the family law and said, hey, Sally Smith, do you want to buy this, this part of the firm? But even then the clients can say, I don't really like Sally, right? So, yeah. Yep.
Does OARC or the inventory attorney who has to go and mop up for somebody who didn't have an opportunity to put together a written plan or agreement have a claim against the estate of the deceased attorney?
So OARC does not. What can be opened is the door for the clients to have claims against, depending on how the firm's operating, malpractice, ethics complaints, obviously, and civil suits potentially. Yeah. So OARC doesn't come in and make a claim of any sort. And I haven't seen anything that even really authorizes payment to them for services in the same way that you can agree to, as I mentioned here, you can agree to pay your assisting attorney like an hourly fee for their time and effort.
So how do they fund this program?
That's a good question. I don't know. I didn't look at that, to be honest with you. That's a good question. I don't have an answer for you. Yeah.
I keep thinking about in other fiduciary roles that we might appoint someone or have an agreement with, trustee, personal representative, agent under power of attorney. We almost always have a successor contingent.
Yep.
Would you do that in this sort of an agreement in case something happens to the person you designated?
Yeah, you can. So you can definitely nominate successors or alternates. And we'll talk about some forms here in a minute, and I think the forms even anticipate that you might have some backups. Yep. Yeah, exactly. Because you just don't know, right? Yeah. Yeah, and it could be that the person you're nominating is older than you, right? And it's good to have a backup plan. So the documents. Agreement to close practice is essentially the agreement or the name of the document that really puts in place this assisting attorney. And we'll talk briefly about that in just a sec. Limited power. So I should put it this way. When I think through creating a plan for an assisting attorney, then this is a set of tools that I look at to put in place for that scenario. So an agreement to close the practice, that's kind of your overarching document, right? That's the meat and potatoes. The limited power of attorney, that's so they can get some access to those financial accounts. But remember, it dies with me. A HIPAA release, again, if I want them to be the one that helps with the determination of my incapacity, they're going to need to be able to get some medical information. So I might do a limited HIPAA release to give them that authority. And then letter of understanding, that's if I want that third party to be the protector of my power of attorney, right? Then I would just do a letter of understanding. It's kind of a rare thing to use. It's really a personal preference. I mean, truthfully, if it's your spouse, you probably don't need a letter of understanding, but your spouse needs to know who it would be to give it to. And what if something happens to your spouse, right? If you travel a lot together, but maybe you don't travel together, I don't know. Authorized signer paperwork, right? That's, again, for my bank account. So something's set up so they have access to my bank account. The agreement to close practice is going to have some language in there as well, but we're going to do as much as we can so they don't run into those barriers that they might encounter. So those are some of the documents. We also want to couple that with will or trust provisions. If I have a will as a solo practitioner that says I leave everything to my spouse and my spouse's personal representative, so forth, so on, is there a conflict now with regard to this person I've nominated to take over and deal with my firm, over the fiduciary roles? Well, if I put some language in my will or trust, I've kind of squared it away. And so there's some recommended language to keep us, just again, button it all down. Update your client engagement letter. In estate planning, I frequently get asked the question, because I'm talking about death and I die a lot in my office in conversations. It's the worst thing to do to kill off my clients during a conversation. And so I die a lot. And as a result, it is not uncommon for a client to go, okay, so what happens if you die while we're doing this? And that's my own creation. But if my engagement letter says something about it, then they know. And it might be as simple as saying, hey, I have an assisting attorney set up. You know, something happens to me, this person is authorized to review my files and will contact you if necessary. List of contacts and important information, right? If they have to step in and do things, it's going to be really hard if they don't know the basics. If they don't know who my malpractice carrier is, they don't even know where I bank, they don't know where to find passwords, they're going to be pulling their hair out and probably cursing me and maybe resigning and letting the successor do it, right? So information is key. Firm procedure manual, that's again part of the information. And then one thing before I go to the next slide is, the other thing too is you could use insurance, keep in mind, to help fund the expense of the assisting attorney, right? If your firm has a life insurance policy that pays out as a result of you dying, then there's some money that comes in that could be used to pay your assisting attorney an hourly fee. This is not going to be a quick task in most firms, right? We like to think we keep up with things, but come on, right? There's some dark recesses in the cabinets where there's those things that you're like, oh, I'll read that later, right? That have no deadline, but now they're coming in to deal with it. Help is available. What I mean by that is fellow attorneys, you know, I'm always happy to answer questions. There's a lot of attorneys, or there's about a handful of us that kind of talk about these issues. Office of Attorney Regulation. They have, and I put the website here, and this will be in your materials, they have a succession planning guide. It is about 62 pages long, but it takes you through, I think they break it down into maybe 5 chapters. It takes you through the work to get here. But even better than that, they give you some base forms. They give you limited powers of attorney. They give you the agreement if you're trying to enter into one of these assisting attorney agreements. It's available on the website, and we're going to give it to you in PDF. When Kyle sends out the stuff, he'll probably include the link because you can go there and get it in Word. You know, I myself, I have one of these in place. I've also, you know, therapists or clients that I work with a lot, they actually have to do something similar because their files can't be touched by people that are not licensed. And so I've created a set of tools for therapists that are similar. And so, you know, there's stuff that can be tweaked. I'm not telling you OARCs is the end all be all greatest thing. I definitely have modified it. They have a long form and they have a short form. And so you can get as complex as you want and you can kind of maneuver them around. I know that the other part that I didn't put on the checklist is figuring out who the heck to do, right? Who to put in this for you. One thing you can do, get another solo that has the same problem, right? That you're close with and have an agreement. I'll do it for you if you do it for me. That's what I did. They may change their mind now that, you know, they've heard the presentation, but because they didn't know what all they were signing up for. But yeah, so the idea is you reach an agreement and they can help. The CBA solo small firm section, I believe, put it on their website now somewhere on CBA. If you email me, I'm happy to dig for it. They started a Google Doc to sign up of people that were looking for an assisting attorney or like willing to kind of swap it with you. You know, you have to be comfortable with it, right? Because you may not be comfortable with it being somebody that you know nothing about, and that's fair. I haven't looked at the list. I don't have any idea if there's a bunch of names on there or not. But yeah, and so there are a bunch of different options out there. I'm happy to answer any questions you guys have. I know it's a lot really quick. Inventory Council I know does help with files. I think there's a way even to turn files over to them. The materials that they put out has a whole section at the end about inventory and destruction and retention issues as well. So, questions? All right. It's a lot. Files.
Yeah, you know, I'm doing it right now. I'm going through, and I mean, okay, I'm supposed to hang on to files in my criminal practice
a long time
until the client is out of prison.
Yeah.
And some of these guys are in indeterminate sentences, and so, you know, and they're younger than I am. I'm sure of that too. So what's supposed to happen with that? I
Yeah.
mean, I'm maintaining the files like I'm supposed to, but I mean, I think I'll die sometime, and
Yeah.
when that occurs, I'm not going to be able to deal with files. So
Yeah.
what do we do?
So in that instance, I would suggest, because I'm not going to tell you I've got a perfect answer for you, but I would probably call Inventory Council. I can't think of his name. You know his name, Fern.
Can't either.
Is it Matt? Maybe.
Jonathan.
That's right. It is Jonathan.
Yeah.
His name is I can't think of his last name, but it's on. I want to say White, but I don't think that's right.
I think it is right.
Is it? His name is on the materials that you get.
Okay.
I would call him and ask him what the options are, because I understand that there may be a process by which you can turn them over to them. But you can also, and the other idea would be reaching out to another attorney and seeing if there's an attorney willing to take on those files. But the likelihood, since they're not money generating, right? So yeah, most attorneys probably aren't going to be willing to, so you're probably left with Inventory Council. And I do think they have a system for which they can take those files and maintain them.
I'd be happy to turn them over to him right away.
I don't blame you. Yeah, I'm sure. Yeah, I can see that.
All right.
But that's a good question, and that's who I would call. Yeah, and his name will be on the attachment to the handout, and you can get it at that website.
All right.
Yeah.
Similar question, but I've got clients that are permanently totally disabled in my system, and the file is still open because they get benefits for life and medical treatment for life, but we just keep it open in the office. But that's a similar question, because I don't know, where we put those files.
Yeah, and I think it's the same issue, right? It's either if there's somebody that kind of takes over your practice, then it's like you get the good stuff, but you also have to keep all these, right?
Yeah, this for 20 years.
Right, and then if not, I think it's probably Inventory Council, because the rules do provide that they can be digitized, right? The files can be digitized; they just have to be maintained. So my guess is it's probably an Inventory Council assistance. If you don't have another attorney to take it. So
Yeah, some of these files are like 30 years old and aren't digitized,
right?
to be honest, but they can be.
Yeah. Well, I figure OARC. I think their system. I think they have a means to digitize things. Is my understanding. But yeah, and I don't know. Again, I don't know if there's any financial issues with that, right? Like a fee or anything. But yeah. Other questions? All right. Hopefully it was helpful. I'm always willing to answer questions. I definitely don't consider myself an expert. I've dealt with it, and so I'm always happy to help any way I can. So, thank you all.
Thank you, Jodi.
Excellent.
That was great.
Oh, thank you.
Fabulous, Jodi.